is Andrea Evans, and in this session, I am going to talk to you about copyrights. So you may be wondering, what is a copyright? Well, first let's step back and make sure that you're clear on the three different types of intellectual property and the distinctions between each type of intellectual property. Patents protect inventions. Trademarks protect the names of those inventions, and copyrights protect written works. So again, you would patent a television, trademark Sony, the brand, and then copyright written materials. So that would be copywriting the scripts of the television show, or even copywriting the instruction manual for your television. So now that you're clear on the three different types of intellectual property, let's move on to copyrights to ensure you understand the benefits, what they are, and how to protect them effectively. So first, a copyright, like we said, protects written materials. So here in the United States, as soon as you put the pen to paper, as soon as you take notes as you're writing notes for this presentation today, you own the copyright in that because that's your written work. Now, although it's not required to protect that copyright with the federal U.S. copyright, it's definitely recommended. Now, here are a list of things that can be protected with the federal copyright. You can copyright literary works, musical works including accompanying words, dramatic works including accompanying music, pantomimes and choreographic works, pictorial, graphic, and sculptural works, motion pictures and other audiovisual works, sound recordings, and architectural works. Now that you're clear on what can be protected with the copyright, it's important to discuss what cannot be protected with the copyright. So often people get confused about the distinction between a trademark and a copyright. So as I mentioned, trademarks serve as source identifiers. So yes, a trademark can be a word, but remember that trademark has to be a source identifier. So consumers need to identify that word with a particular product or a service. For instance, you may use Evans IP Law for shoes. So when your customers see Evans IP Law on the packaging of shoes or inside of the shoes or on the price tag, they know that that's a source identifier. So that serves as a trademark. But keep in mind, if you don't qualify for trademark protection because you're not using Evans IP Law on a particular product or a service, you cannot copyright a word. So you can't just copyright your favorite word for protection. Remember, it needs to be more than one word. Now, if you have a book, for example, you can actually copyright that book, and then if you have a series of books and that book has a particular title that serves as the series name of the book, that can be protected with a trademark. Now, here's another myth that people often talk about when they think about copyrights. Just because you see something on the internet doesn't mean that it's free. So often where people get in trouble is they're doing a presentation or they're copying and pasting things saying, oh, it's on the internet, I'm going to just copy and paste it to my site. Be careful with that because you can be liable for copyright infringement. Now, here's another myth about copyrights. Just because you give that person credit saying that they are the author of the work that you copied doesn't necessarily mean that you aren't infringing on a copyright. So just because you have permission doesn't mean it's okay. So again, you cannot copyright a name. You would trademark that name provided that it serves as a source identifier. Secondly, just because it's on the internet doesn't mean it's free. So that doesn't mean you're allowed to just copy and paste. And last but not least, just because you give the author credit of something that you copied and pasted doesn't necessarily mean that you have permission to use that. Now, the best thing you can do is, of course, ask for permission to use what you're finding, maybe pay a license fee, or just simply create your own original works. Now, copyright, as we discussed, is a type of intellectual property. So whatever you can do with real property, you can do with intellectual property. You can license it, you can assign it, you can sell it, you can will it. It's extremely valuable. And so you want to ensure that you're reviewing your Australian laws to ensure that you're in compliance. And in terms of the United States, you want to ensure that at some point you register your copyrights with the federal copyright. I'm going to now explain the benefits of registering for a copyright. So even though it's not required to register your federal copyright, it's recommended because there's several benefits. Here are the benefits of registering your copyright. Registration establishes a public record of the copyright claim. So of course, when someone infringes on your copyright, the first thing they say is they didn't know. But having that registration establishes a public record. Next, before an infringement suit can be filed in court, registration is necessary for works of U.S. origin. So for example, if you write a book and then publish the book, and then it's determined that Jane Doe copies that book, it's required that you have that federal copyright registered before you can file suit. So because that copyright is registered after publication, you'll get less damages than you would have if you registered that copyright prior to publishing the work. Last but not least, registration allows the owner of the copyright to record the registration in the United States Customs Office for protection against importation of infringing copies. I'm sure you're wondering, when can you use someone's copyrighted works without necessarily having to ask them for permission and to ensure that you aren't infringing on their work? Well, the standard in Australia is fair dealings. The standard in the United States is fair use. Although the names of the standards appear to be different, my research shows that the defenses appear to somewhat mirror each other. Now, I am a U.S. intellectual property attorney, and I definitely recommend you seek the help of a qualified Australian attorney if you have questions about how to register your work in Australia and you have questions about permissions to use others' work based off of these defenses. The first defense would be educational purposes. So if you're using someone's copyrighted works for educational purposes, that's considered a fair dealing in Australia or fair use in the United States. Secondly, for parodies, if you create a parody based off of the copyrighted work, that will be considered fair dealings in Australia and fair use in the United States. Next, for news. So you'll notice when you watch the news, they may be showing someone's picture or video. That's fair dealings or fair use, and that could be a defense if that's how you intend to use it. Last but not least, for criticism. So if you're showing a movie and you're providing criticism, the movie wasn't good, or you're providing positive criticism as you show that movie, that can be considered fair dealings in Australia and fair use in the United States. Again, my name is Andrea Evans. I'm the owner of the law firm of Andrea Hence Evans, an intellectual property law firm, and I'd like to thank you for watching this presentation on copyrights.